Good morning, everyone, and welcome to today's Knowledge Bank. Today's session is entitled Recovering the Cost of Fire Safety Works as a Service Charge or Not. Today's webinar is going to be hosted by Roger Hardwick, Partner, and Emma Bush, Senior Associate at Brethertons Solicitors. If you have any questions throughout the webinar today, then please submit them via the Q&A box at the bottom of your screen, and we will try to get through as many as possible at the end. The webinar is also being recorded and will be available to watch back this afternoon if needed. And that is all from me. I will now hand you over to Emma and Roger.
Thank you, Vicky. We start the slides.
We're just going to share our slides.
Excellent. We all go? Oh, there was a picture of a big penguin there. I think we're okay. Right. Good morning, everyone, and welcome to the Brethertons webinar hosted with News on the Block. It's a webinar about fire safety, recovering the cost of fire safety defects. Before we begin, just the usual disclaimer: this is a general webinar only. We're dealing with general topics, not the specific facts of individual cases. If you do require any individual advice about your case, please contact us after the webinar, and we'll do our best to answer your questions. And do bear in mind, and this is particularly relevant here, the law changes rather rapidly in the field of building safety and fire safety. So if you're watching this back in 6 months' time, there is a good chance the law has changed. A real health warning with this one. So my name is Roger Hardwick. I'm a partner with Brethertons Solicitors, partner with the residential leasehold team. Amongst other things, I deal with building safety and fire safety issues as they relate to service charges. I'm joined today by a senior associate in our property litigation team, Emma Bush, and we're going to be talking to you about recovering the cost of remedial work and interim measures as a service charge or not, as the case may be. So I think whether you manage a building or live in a building that contains serious fire safety defects that were identified post Grenfell, then you're likely to come across some serious issues. And the first question that you're likely to ask yourself is whether who's going to pay for it, and whether any of these costs could potentially end up being charged to the leaseholders as a service charge. And I should emphasise that we're not saying that you should or shouldn't recover these costs as a service charge, but whether you can is an issue I think that everyone should think about fairly early on, particularly because there are certain entities out there like RMCs and RTM companies that have no other source of funds and that may need to carry out this work rather rapidly. And although they may look to recover the costs from other entities at some point in the future, they'll be looking to fund these costs in the sort of immediate present in order to carry out urgent health and safety and fire safety works. So these are questions that I think need to be addressed, and whether you're a property manager or a leaseholder. And they're complicated questions, and they become a lot more complicated since the coming into force of the Building Safety Act. So the first thing that we're going to be talking about is understanding the lease and interpreting the lease to see whether you can recover the costs associated with remedial work or interim measures as a service charge. I'll move on to the Building Safety Act, in particular Part 5 and Schedule 8, which contains a range of limitations which prevent the recovery of service charges that relate to remedial works and interim measures in certain cases and in relation to certain buildings and certain types of leaseholders. And we'll talk you through the qualifying conditions and what's been dubbed the statutory waterfall. And Emma's going to talk to you about leaseholder deeds of certificate and landlord certificates and how they're relevant. Because it is relevant to recovery of service charges, we'll be dealing with other potential sources of funding and suing people claiming against other responsible entities to recover the costs associated with remedial works and so on. And I'll deal with the definition of associated companies and persons last. That's relevant, as you'll see, to various provisions in the Building Safety Act which look to cut through the corporate veil and enable liability to be passed on to associated companies and other individuals. So some very important provisions there to consider. But before we start talking about the building safety legislation, as I always start in all of my webinars, the lease is the best starting point and the key to a lot of contractual recovery. So there are several things to look at in the lease, and most leases contain a list of recoverable expenditure, that is expenditure that is allowed or permitted to be recovered as a service charge. You might find this in a schedule, or it might be listed as a set of obligations on the part of a landlord or management company. And one typical obligation you'll find in most, if not all, leases that put this obligation on the landlord or management company is an obligation to repair the structure and exterior of the building, or indeed the common parts of the building. And an obligation to repair is only going to arise when the subject matter of the covenant has fallen into disrepair. So that occurs when the common parts of the building, the structure and exterior, if you like, fall below or deteriorate physically from a previous condition. So one of the issues with that and fire safety defects is that it deals with fixing something that's broken. So if you have a building and the roof caves in, or it's deteriorated to the point where it's leaking, that's clearly in disrepair. But a building that's constructed in a defective manner, it's constructed with cladding which is combustible or has various internal fire stopping and compartmentation issues, or was constructed without the necessary cavity barriers, then that building isn't in disrepair. It hasn't deteriorated. When it was constructed, it was defective. And there's a number of cases which deal with that point. Post Office and Aquarius Properties Limited is the most often quoted case, and that was a case involving basement premises which flooded every time the water table rose. And the court in that case found that the building wasn't in disrepair. It had just been designed with a hole in it in the bottom of the door, which allowed water in. And so the tenant in that case wasn't liable to correct that defect. And there's been a number of other cases, one that I was involved with called Tedworth North Management Limited in Miller, which involved a management company that replaced a load of windows that only showed minor decorative disrepair, and 20% of them had mould spores, but generally they were okay. And because the covenant there was limited to repairing the windows, the management company wasn't entitled to recover the cost of replacing them. So if you're dealing with a lease that limits the obligation and the rights to recover service charges to that of repair, it's unlikely to extend to replacing ACM or high pressure laminate, or removing and replacing expanded polystyrene, internal fire stopping and compartmentation issues, fixing fire doors, upgrading them from FD20 to FD30, that sort of thing. It's unlikely to fall within repair. The lessees of the St Saviour's estate in Southwark was a case involving fire doors, which determined just that point. But a lot of leases, and more modern leases in particular, do contain more broader covenants, and you might find words such as renew and keep in good condition. Those phrases is probably 50-50 as to whether or not you could rely on them to, say, remove and replace combustible cladding. There's a couple of cases that could go either way. There's nothing specifically on fire safety defects. Probably the closest one is a case called Credit Suisse and B Gas Nominees Limited, which was a case that did involve defective cladding that was allowing water into the building. And in that case, a covenant to renew and keep in good condition was found to extend to rectifying that. But there have been other cases which have interpreted those phrases more narrowly. probably the clause that I've seen relied on the most is a clause that obliges the landlord or the management company, as the case may be, to comply with statute. And in that case, in my opinion, although I don't think there are any reported decisions in any superior courts on this, but in my opinion, a clause that requires a landlord to comply with statute would extend to carrying out essential fire safety works that are necessary to protect the occupants of the building. And that's mainly because of the Regulatory Reform Fire Safety Order 2005, which contains a list of duties for the responsible person. The responsible person is likely to extend to anyone who has overall responsibility for maintaining the common parts of the building, or for ensuring the health and safety of the occupants of the building. And those duties extend to taking general fire precautions, which is defined to include taking measures to minimise the risk of spread of fire and minimise the risk of fire. And it's difficult to see how that wouldn't include removing combustible cladding, or carrying out other remedial work that's necessary to significantly reduce the risk of the spread of fire. One slight caveat to that is that it is currently unclear, certainly arguable, as to who the responsible person is in relation to flat front doors that are demised to leaseholders under the terms of their leases. It was in the Fire Safety Act 2021 amended the Regulatory Reform Fire Safety Order 2005 to bring within its scope aspects of the building that are demised, including flat front doors and balconies. So they are within the scope of the 2005 order. However, it doesn't deal with who the responsible person is, and arguably, because the leaseholder owns and has control and is responsible for maintaining the door, they are the responsible person in relation to that door, and therefore the ones who are obliged to carry out any necessary fire safety works. I think that some judicial guidance is going to be necessary to deal with that particular question. And then finally, you might find in a lease something that lawyers refer to as a sweeper clause. So particularly in more modern leases, you'll get a sort of catch-all provision that will allow the landlord or management company to recover the cost of anything that's not specifically mentioned, in order to kind of cover stuff that may arise in the future that the draftsman didn't particularly think of when he was drafting the lease. The wording of sweeper clauses can vary. There's been an enormous amount of case law on sweeper clauses. A lot of it relates to the recovery of legal costs. It really depends on the wording that's used as to whether you could rely on that. My view has always been, sometimes you get clauses that specifically refer to rectifying inherent defects or to improvements, and if you do, I think those would almost certainly include the carrying out of remedial work or interim measures such as fire alarm installations or upgrades, sprinkler system installations, and so on. But you might also see a clause that refers to doing any works, matters, or things that might be necessary for the benefit of the occupants or leaseholders in the building. I think that would probably be sufficiently broad. But then some are more narrow and might just refer to services, and then there's the question of whether a work is a service, and arguably it isn't. So I think you have to look at the specific wording of the clause and really try to decide whether or not your fire safety works would be included within it. So I think that deals with the contractual position and assessing whether or not these sort of costs can be recovered under the lease. But that's only the starting point, because after you've looked at the lease, you then have to consider the Building Safety Act, which came into force last year. Well, various parts of it came into force last year. Some parts of it aren't currently in force. And the reason that this is relevant is because Part 5 and Schedule 8 of the Building Safety Act contain a whole host of very significant limitations on the sort of costs that can and can't be recovered from leaseholders, specifically costs relating to fire safety and building safety defects. So I'm going to talk to you about what these provisions apply to. You may have heard them referred to as the statutory waterfall, and I'll come on to that later. But there are various conditions that have to be satisfied in order for these limitations to apply. So I'm going to talk to you about those, and then I'll talk to you about the limitations. But the first thing that you have to look at when you're trying to consider whether or not certain costs can be recovered as a service charge is whether Part 5 and Schedule 8 of the Building Safety Act apply. And the first thing to look at is whether or not the building you're dealing with is a relevant building within the meaning of Section 117 of the Building Safety Act. Because if it's not a relevant building, then none of this applies. And you can just look at the contractual provision and some of the other provisions that we'll talk about later. So a relevant building will be a building which is at least 11 metres or at least 5 stories. Now, Section 118 tells you how to work that out. By measuring the building, you measure it from the lowest point of the ground that's adjacent to the building. So sometimes you'll have a building where the ground is at different points. So you measure it from the lowest point of the ground to the finished surface of the top floor of the top story. So not the top of the building, but the finished surface of the top floor of the top story. And that's how you calculate the height. In terms of working out the number of stories, you disregard any story that's below ground level, and you can count a mezzanine level as long as its internal floor area is at least 50% of the largest story in the building that's above ground level. So the building's got to be at least 11 metres or 5 stories. It's also got to be a self-contained building or a self-contained part of a building. So these conditions mirror the definitions in collective enfranchisement claims and right to manage claims. So those of you that have done collective enfranchisement or right to manage claims will know all about these. A self-contained building is one which is structurally detached, and that means or is determined as a matter of fact and degree by looking at the degree of attachment. So if you have two buildings which are attached by a piece of plastic weathering, as in number 1 Deansgate, then that won't be a structural attachment, and those buildings will be structurally attached. But two houses that are joined side by side as a part of a terrace will be structurally attached to one another. So it's a question of fact and degree. One of the cases on that point recently was a case called Powergraven Consensus, which involved 5 blocks, and underneath those blocks was one single underground car park which linked them all together. And notwithstanding the fact that the 5 blocks were capable of standing on their own, they were all found to be structurally attached to one another by virtue of the underground car park. So the 5 blocks together and the underground car park were one building. Underground car parks are probably the sort of most important thing to look at, the one thing that catches people out. So do bear that in mind when you're trying to decide what your building is. You can also, a building can, or rather premises or relevant building, as in this case, can also be a self-contained part of a building, which has got to satisfy 3 definitions. It's got to be divided vertically. That means a clean vertical division, no deviation except for de minimis variation, which means very small. And there was a case called Solitaire in 1-16 Finland Street RTM Company Limited, where a 2% deviation in an underground car park was held to mean that the building wasn't divided vertically. It's got to be capable of independent redevelopment, and it's got to contain independent services or services which could be provided independently without significant interruption. This tends to involve, shared water services that share a single pump equipment and water tanks and so on. And then you have to look at how easy it would be to separate the 2 services. Okay, can we have the next slide? Good stuff. So you've had a look at whether it's a relevant building. Now, you also have to have a look at a number of other definitions. The Building Safety Act loves definitions. There are definitions all over the place. They're littered throughout the Act, making it incredibly difficult for even lawyers to try and understand what's going on. But
we have put some definitions at the end of the PowerPoint, so don't worry about trying to scribble down all of the answers.
I've tried to cover them. So most of the limitations limit the recovery of relevant measures that relate to relevant defects. So I'm going to talk about the definition of relevant defect first, because if it's not a relevant defect, again, similarly to if it's not a relevant building, then none of these limitations will apply. So a relevant defect, very broadly, arises as a result of anything done or not done, or anything used or not used, first of all. So that's designed to capture pretty much everything. In connection with relevant work. So there you go, there's another definition for you. And these are works that relate to the construction or conversion of the building between the 28th of June 92 or the 28th of June 2002, or work undertaken by a relevant landlord or management company which completed between those dates, or work undertaken after that to remedy a relevant defect. So, essentially, work to construct a building or convert a building between 92 and 2002, 28th of June in each case, or any kind of other work which might involve the installation of something that turned out to be defective. So, if a landlord or management company installed combustible cladding on a building that had already been constructed between 92 and 2002, that would also count. But also work which attempts to remedy a relevant defect, but presumably fails. So that's quite a dangerous one, because I've come across a few cases actually where work has been attempted, but it hasn't been carried out properly, and then the person that carried out that work ends up on the hook. The sort of things that it won't cover, obviously any work prior to the 28th of June 1992, so buildings that were constructed a very long time ago. Building works which were undertaken by leaseholders. So, where leaseholders have carried out alterations to their doors, for example, and those alterations have made the doors less fire resistant, then that sort of thing wouldn't be a relevant work within the meaning of the legislation. The work also has to cause a building safety risk. And by that we mean work which causes risk to the safety of people in or about the building, arising from A, spread of fire, or B, the collapse of the building or part of it. So work to remedy a defective boiler or a defective heating and hot water system is not going to be covered. It's not a relevant defect. However, it's not just fire safety works that are covered by the Building Safety Act. I had a case involving a balcony which collapsed, and other balconies which are at risk of collapsing, and that clearly is within the scope of the legislation. So we're covering relevant measures that relate to relevant defects, and relevant measures defined very broadly. It includes obviously remedial work, so the removal and replacement of defective cladding, for example, or carrying out remedial work to install intumescent strips, reduce the gaps between doors, remove penetrations in walls, that sort of thing, fire stopping and compartmentation remedies. But it also includes interim measures such as fire alarm upgrades, waking watch, installing sprinklers, and so on, stuff that's designed to mitigate the risk until the remedial work is undertaken. And finally, probably the last important definition of many, most of the limitations, all but one, in fact, one important one, but still, apply to leaseholders who own a qualifying lease. And by qualifying lease, we mean a long lease of a single dwelling. So a lease of multiple dwellings wouldn't be covered, including head leases. The leaseholder has to be liable to pay a service charge under the lease. Perhaps that's obvious, because if they weren't liable to pay a service charge, they wouldn't be worrying about whether or not you could recover the cost from them. The lease has to have been granted before the 14th of February 2022. and we'll be touching on this later. The reason this is important is because when you extend the term of a lease, do a lease extension, you have to surrender the existing lease and grant a new one, which may inadvertently have the effect of rendering a lease non-qualifying. And finally, at the beginning of the 14th of February 2022, the dwelling either has to be the leaseholder's only or principal home, or the leaseholder mustn't have owned any other dwelling, or the leaseholder can't have owned any more than 2 additional dwellings in the UK. So if you are a leaseholder that owns 100 dwellings in the block, you're not going to be a qualifying leaseholder. So the next question is what the limitations are. If you've gone through all of those hurdles, you've determined that you own a relevant building, that you're dealing with a building that's covered in ACM cladding, so it's clearly a relevant defect. The building was constructed in 2005, so it's constructed within a relevant period, and so on and so on. Now you have to consider what the limitations are and what, if anything, you can recover as a service charge. Now, the idea of a statutory waterfall is that there's a range of limitations, and you start with the kind of most important one and work your way down. And the first limitation, it applies where the relevant landlord, by which we mean that the landlord under the lease on the 14th of February 2022, was responsible for the relevant defect or associated with a company or person that was responsible. In this case, no leaseholder pays. It doesn't matter whether you're a qualifying leaseholder or not. And this is dealt with by paragraph 2 of Schedule 8. Where are we time-wise, by the way?
Just 25 minutes.
Don't have a clock anyway. So, okay, we've got 25 minutes.
We're 25 minutes in.
Okay, good.
You're right.
Excellent. We're okay. We're on track. I do have a tendency to talk for too long. Right, so a relevant landlord's responsible for the relevant defect, nobody pays. So by that we mean a landlord that was the developer that constructed the building or was responsible for conversion, or was part of a joint venture that was responsible for the development or conversion of the building. But importantly, it also includes anyone that undertakes work in relation to a relevant defect. So it could include somebody that attempts to remedy it and fails. So I think it's important to look at the wider kind of definition, but generally speaking, you'll be looking at a developer landlords. So if you've got a landlord who developed the building and constructed the combustible cladding or did whatever else has resulted in internal fire safety issues, then the legislation provides that nobody in the building will have to pay anything. I do appreciate that causes some problems for RTM companies and RMCs. There is a way out, which I'm going to talk to you about shortly. If your landlord isn't a relevant landlord that was responsible for the relevant defect, then you go on to the second of the statutory waterfall limitations, and you ask yourself whether the relevant landlord met the contribution condition on the 14th of February 2022. So what this is all about is was the landlord worth a lot of money? The idea is landlords that have a lot of money should pay for the remedial work. That's putting it very crudely. The legal terminology that's used in the legislation is landlords that meet the contribution condition. And the contribution condition is having a net worth that exceeds £2 million per relevant building that's owned by the landlord or the landlord group, which I'll come on to shortly, on the 14th of February 2022. So you're not just looking at the landlord, you're also looking at any company that's associated with the landlord. And I'll talk to you about associated companies at the end because they're relevant to lots of things in the building safety legislation. But just bear that in mind. You're looking at the whole of all of the companies that are technically associated with the landlord. And if within that landlord group, the net worth of all of the landlords taken, all of the landlord group taken together is more than £2 million per relevant landlord that's owned by the landlord group, per relevant building that's owned by the landlord group, then they'll meet the contribution condition. and the net worth is calculated in accordance with the Building Safety Leaseholder Protections England regulations, Regulation 5, and essentially it's total assets minus total liabilities minus intangible assets. And you determine that by looking at the most recent filed accounts that were filed after the 14th of February 2017, but before the 14th of February 2022. So for the most part, you're probably going to be looking at audited accounts, for the year ending 2021, if indeed they've been filed. And it's a bit more complicated than that, and there are ways of establishing the net worth if no filed accounts have been no accounts have been filed and so on. But I won't go into the detail here. It's in the protection regulations if you want to look at it. If you have the burning desire to look at calculating the landlord's net worth.
Or tragic insomnia.
Or tragic insomnia, or you could just approach us and we'll try and work it out for you. So if you're dealing with the relevant building and the relevant landlord wasn't responsible for the relevant defect, so they're not the developer, they're just an investor that has nothing to do with the development of the building, and the landlord has determined that they don't meet the contribution condition. Landlord certificates are relevant for this, which Emma's going to be talking to you about later. So you may have received a landlord certificate that confirms they don't meet the contribution condition. So now you have to go on to consider, right, well, what other limitations are there? Sorry, I probably should have said that if you do meet the contribution, if the relevant landlord does meet the contribution condition, then no qualifying leaseholder pays. If neither of those two apply, then you go on to the third limitation, or the third series of limitations, I should say. And there's a range of them. And they depend on where the property is located, how much it's worth, amongst other things. So you can find these limitations in paragraphs 4 to 11, Schedule 8 of the Building Safety Act. And the first thing to note is that cladding remediation isn't recoverable at all. So removing combustible cladding, it won't be recoverable. Not even up to the cap. If you're dealing with other non-cladding related issues, perhaps interim measures, perhaps you're dealing with fire stopping and compartmentation works, then you have to look at the caps. So there is a total cap on the amount that's recoverable, which is £15,000 in Greater London, £10,000 outside of London. But there's also an annual cap, so you can't recover any more than 1/10 of the total cap within any 12-month period. And a lot of people forget about the annual cap and just look at the total. But it's important to look at the annual cap as well, because if the lease doesn't allow you to spread costs between different accounting periods, then in actual fact, your real cap will be the annual cap, which might mean that you're limited to 1,500 per leaseholder, or 1,000 per leaseholder outside of Greater London. The cap for any dwelling which is worth less than £175,000 outside of London, or £325,000 in London, will be zero, and professional fees that relate to relevant defects will also be zero. So you have to look at the type of defect you're dealing with. Is it cladding? Is it not cladding? Where's the property located? What are the flats worth? And one of the things that you might look at also to decide on whether any of these apply, because they only apply to qualifying leases, is the leaseholder deed of certificate, which will tell you whether or not the leaseholder owns a qualifying lease, and Emma's going to be talking to you about that shortly. I did mention earlier that one of the issues with these limitations is if the building is being managed by an RMC, by which I mean a management company that's leaseholder owned, and that has no assets or income stream apart from the service charges that it's able to collect, or if it's managed by an RTM company, which similarly will have no assets and income stream apart from the service charges that it's able to collect, then they might find themselves in an unenviable position of having to carry out some fairly serious and substantial remedial work without having the means to fund it, particularly if the landlord is the developer, but even if he's not. If you've got a building where 60 or 70% of the leaseholders are qualifying leaseholders, it's no good if the RTM company or RMC can only theoretically recover 30% of the costs that they need to carry out these works. And I mean, it's understandable why these limitations are here. They're to protect leaseholders from problems that they didn't cause, so they're perfectly fair. But at the same time, you potentially have an issue where you've got leaseholder managed and owned companies that can't carry out this work because they don't have the funding to do it. And in these situations, I can tell you about some of the legal rights that are available to those companies that might assist. They won't solve all of your problems for reasons that I'll touch on later. But the Building Safety, Leaseholder Protections, Information, etc. England regulations, that's a bit of a mouthful, isn't it? I'm going to call it the information regulations. The Building Safety Act has given rise to, spawned a significant number of regulations that have an increasingly long names.
Very poorly named.
Very poorly named. So you have the information regulations which deals with this. Unfortunately, the information regulations were had a few errors in them, so they had to be amended by the Building Safety, Leaseholder Protections, etc. England Amendment Regulations 2023. I told you they got longer. The basic principle in the information regulations as amended is that the RTM, well, anyone that has to carry out this work, but particularly RMCs and RTM companies that have no other way of funding it, can recover the shortfall from people that are responsible or possibly other landlords in the building. So there are different regulations that apply to different parts of the statutory waterfall. So Regulation 3 provides that a landlord that incurs or has a liability to pay the cost that relates to a relevant measure or something like a remedial work will be able to serve a notice on the responsible landlord, the person who's responsible for constructing the building, for example, to cover the entire amount. I'll come on to what that notice might look like later. The information regulations, as they're currently drafted, doesn't say what that notice should say, but as we'll see later on, the amendment regulations deal with this and tell you what must go in the notice. So Regulation 4 of the information regulations deals with what happens if the landlord meets the contribution condition, and again, other landlords in the building or RMCs or RTM companies can serve a notice on the landlord who meets the contribution condition, asking him to cover the proportion of the cost of the remedial work that would otherwise be payable by all the qualifying leaseholders. And then Regulation 5, which is probably the one that I think will be used the most, deals with what happens when the other caps and limitations apply. And I imagine, although it refers to landlords, and landlords are defined so as to include RFCs and RTM companies, Regulation 5 will mostly be used by RMCs and RTM companies that have a shortfall because there are caps that apply. They can't recover more than £1,000 per leasehold or £1,500 per leasehold, and they need to cover this shortfall somehow. And so Regulation 5 gives them the right to serve a notice on the landlords within the building to cover that shortfall. And there are different categories of landlord. A Type 1 landlord is the freeholder or someone who owns 90% of the stories. A Type 2 landlord is a landlord that owns between 40 and 90% of the stories, and a Type 3 landlord is someone that owns less than 40%. And then tells you how to calculate who pays what. So generally speaking, a type 1 landlord will pay 3 times as much as the type 3 landlord, the type 2 landlord will pay twice as much as the type 3 landlord, and so on. And so they'll just get a portion between the different landlords. And the regulations also say that if you own a leasehold interest in any part of the building, you're deemed to hold the entire story for the purpose of calculating what percentage applies. So if you are a landlord that might be liable to cover the shortfall, and you receive a notice from an RMC or an RTM company or another landlord to pay remediation amount, you have 30 days to appeal to the first tier tribunal property chamber, and the grounds on which you can appeal are fairly limited. So if it's a regulation 3 notice, you can appeal on the ground that you're not the responsible landlord, or if it's a regulation 4 notice, you can appeal on the ground that you didn't meet the contribution condition. In all cases, you can argue that the cost of the remediation works isn't accurate, or that your share hasn't been accurately calculated. But it has to relate to one of those specific things. Right, okay. I've been given my 20-minute marker, so I'll pass you over to Em shortly. The amendment regulations are going to amend the information regulations, and they're going to say what must go in a notice to pay the remediation amount, and they're also going to give the landlord the right to request an extension of up to 30 days to appeal to the FTT. They also contain another important provision in relation to remediation contribution orders, but I'm going to leave that one to Emma. So I think that's me done until we're talking about associated companies. Over
and
to
more
you.
definitions. So Roger's briefly touched on something called landlord certificates, which I'm sure everyone's heard of over the past 12 months and possibly dreads. So the Building Safety Leaseholder Protection England regulations, protection regulations, which, believe it or not, is the shortest name of any of the regulations that's come out, gives us some information and the prescribed requirements for a landlord certificate. So this is a document which a landlord is required to complete in a relevant building, and the purpose of the document is to ascertain whether a landlord meets this contribution condition, and broadly that's £2 million per relevant building in the landlord group, which we touched upon earlier. And it's a multi-page document and requires a lot of information to be collated, and a landlord only has a 4-week period to collate that information. So actually, if you've got a large corporate structure and you don't have to hand, accounts for relevant years for 4, 5, 6 different companies, it's quite a task for a landlord to complete. Now, if a landlord doesn't complete their certificate, they are deemed to meet that contribution condition, which is possibly very good news for leaseholders, and not good news for landlords, and effectively means that a landlord will be deemed to have met all of the, or be deemed to be responsible, for the relevant defects for all leases, so not just qualifying leases, and we'll need to cover the cost of those remediation works. There's a second rationale which sort of means exactly the same thing, that they're deemed to meet the contribution condition, and as such have to pay for remediation works for qualifying leaseholders as well. So the distinction between those two sort of resulting factors are not entirely clear in the regulations, which is not a shock to anyone that is dealing with them. Whether that's going to be clarified at all in any of the amendments that we're expecting, TBC, and if we do another webinar in 6 months' time, we might have an answer to that. So there are 4 triggers which are set out in the regulations as to when a landlord has to supply a certificate, and they're not necessarily triggers that we were expecting before the legislation came out. So when a current landlord makes demand to a leaseholder for payment of a remediation service charge, that is anything in a relevant building to remedy a relevant defect, that makes sense rationally. A landlord has to prove that they do or don't meet the contribution condition, because that affects the amount that can be recovered, and that's when we go down those caps and the waterfall and all of those sorts of things.
Within 4 weeks of becoming aware of a relevant defect, and it's likely that this doesn't apply to defects they became aware of before July 2022, although that's not currently tested. So again, in 6 months' time, that position may be different. The things that we didn't expect to trigger a landlord certificate is within 4 weeks of becoming aware of a sale. What's not clear in the regulations and another hole that's been identified is what is becoming aware of a sale. When you sell the property, is it up to the current or the incumbent leaseholder to tell a landlord that they're selling a property? Is it on request of, for example, the management pack or details of service charge apportionments? But at that trigger point, the landlord has 4 weeks to provide a landlord certificate. The rationale being that a buyer will need to understand if they are purchasing a qualifying lease and if there's defects in the building, what service charges, they'll be responsible for, and what the landlord will be responsible for. And then finally, a leaseholder can request a certificate at any time, and the landlord has 4 weeks to provide it. There is a standard form and content for the certificates provided in the regulations, and as I say, that it's particularly onerous on the landlords to complete. Once they have completed one landlord certificate, that is not a hard and fast, they don't have to complete another certificate, although the information is generally collated. If there is a new defect, the triggers come round again, and a landlord will have to provide a further certificate to the leaseholders, again within a 4-week period. A leaseholder deed of certificate is less onerous. It is something that is requested by a landlord or a relevant landlord, and allows them to ascertain how many of the leaseholders in the building are qualifying leaseholders, and as such would benefit from further service charge protections compared to those that are not qualifying leaseholders. This is a much shorter certificate. It's basically a tick box exercise. For example, do you own more than one property as of 14th of February 2022? Do you own more than 3 properties as of that date? And within 5 days of becoming aware of a defect, a landlord has to make a request for a leaseholder certificate. The leaseholders have a longer period to complete a much more straightforward certificate, which is 8 weeks, but a landlord has a lot of steps that they have to take to obtain that leaseholder deed of certificate. So when the leaseholder deed of certificate is first sent out, within the period of 7 to 14 days before the deadline, a further chaser notice has to be sent out. And there also has to be a telephone call if the leaseholder telephone number is held on record. And if a landlord fails to go through all of those steps, the leaseholder, whether or not they've completed their deed of certificate, is deemed to be a qualifying leaseholder. So it could be a benefit for those leaseholders that are not qualifying leaseholders to perhaps not complete their certificate and rely on the landlord failing to jump all of those hurdles. And in relation to that specific defect, for example, they'll be deemed to be a qualifying leaseholder. So that's certainly a hole in the regulations that we're waiting for amendments on.
But it's that sort of 5 days is a very short period of time. If you become aware of a sale on a Friday, you essentially have until the following Wednesday to request a leaseholder deed of certificates. And it's very easy to miss that. If it arrives in the inbox of a property manager over the weekend who's on holiday, you could easily miss that email and find yourself with a leaseholder that owns 100 flats, which is deemed to be a qualifying leaseholder because you haven't complied with the prescribed steps. So it's very onerous, actually. But there you have it.
I think a lot of landlords are actually asking for leaseholder deeds of certificate on account to hold on record as a bit of an administrative exercise, which certainly does seem to be a sensible idea. A remediation order. So I think we briefly touched upon these earlier, and it's not to be confused with a remediation contribution order. Again, the naming of some of these orders and steps within the regulations have caused unnecessary confusion. But a remediation order is a tool which can be used by what is defined as an interested person, requiring a relevant landlord to remedy a relevant defect in a specified relevant building. So again, lots of definitions here, but what it effectively is an order to the first tier tribunal to force a relevant landlord to remedy a defect if they're not taking action. And interested person is a wide definition in this case, and it allows anyone with a legal or equitable interest in the building to make the application to the tribunal, effectively an order for specific performance to do works that is required, that is causing a building safety risk. It's enforceable with the permission of the county court. So once you've had the FTT order, your landlord doesn't do the work, you can go to the county court for enforcement. And again, this could be a useful tool for RMCs or RTM companies, perhaps to force landlords to do work if they're not being undertaken.
Or can be used against an RMC.
Or against an RMC, yeah.
So I think the key thing about remediation orders is that it's an order to carry out the work. It doesn't say anything about actually, and in a way, it doesn't really have a place in this webinar, but it would be strange to talk about remediation contributions without remediation orders. It's an order to carry out the work. So it can be made against the RMC, but it doesn't say anything about who should be paying for it. So if you need work to be carried out urgently, then the remediation order is your tool, but otherwise, it's going to be the remediation contribution order that you're looking at.
Which is a fab segue into this slide. So the remediation contribution order is the order dealing with who pays effectively, or who pays a contribution towards the works that need to be done. So again, with RMCs, RTM companies, as Roger alluded to, might have a gap in their service charge recoverability. They'll be looking at a remediation contribution order against, for example, a developer landlord, if they're within the relevant time period, to pay a percentage of the cost of the works. So this is when we're looking at a specified body or corporate or partnership to make that payment, and the payment has to be made to a specified person. So that might be a nominee of the RTM company, for example. It may be to a specific leaseholder who could make a remediation contribution order. The order can be for a specified amount or payments of a reasonable amount in respect of specified works that are going to be done. So the difficulty with an RCO application is being able to ascertain exactly what works need to be done and how much they're going to cost. What remediation contribution orders might also assist with is an application, for example, to get reports on defects to allow you to ascertain the entire extent of the works that need to be done to remedy a defect here. So when that payment is ordered, it has to be paid by a specified time, or to be made by demand following a specific event, and that could be, for example, acceptance of a contract to do the works. So that's very briefly what a remediation contribution order will cover.
I think it's very, I mean, it's hard. One mustn't understate the importance of RCOs, and they're a very useful tool. And you can use them to cover future costs as well as existing costs. So we have a case on at the moment where the developer was a company that's become, well, it's dissolved, but because of the associated company rule, we're able to cut through and go to the group company and apply for a remediation contribution order against the group company. But the one thing which is slightly unclear at the moment, it refers to the cost of remedying relevant defects. And it's unclear what that means. That's actually covered in this slide, isn't it? I thought it was covered in the last slide.
No, that's absolutely fine.
I've stolen your thunder.
You stole my thunder. It's all right. We've only got 8 minutes to go. So effectively, what we're unsure about is interim measures, for example, your fire alarm upgrade, sprinklers, and that sort of thing, whether they can be included in your RCO applications. And just on that slide, you'll see some slightly clearer definitions again, which are in the information regulations. Moving very swiftly on, we've got claims under the Defective Premises Act 1972, so a slightly archaic piece of legislation which has been amended by the BSA. Effectively, the amends deal with, or the largest part of the amends deals with the extension of the limitation period to either 15 or 30 years from 6 years, and allows claims to be brought in the county court for works which haven't been done in a professional manner, and if there's an issue in terms of the ability for the building to be habited or fit for human habitation, and there's a specific case on that. Moving very swiftly on, as I said, there's an amend to the limitation work, and you can claim for the cost of that work any special damages, so specific losses or pecuniary losses, and general damages for loss of amenity, so potentially the loss of a value of claim to a property, or if a property's been sold at an undervalue, or you haven't been able to rent the property, all of those sorts of things. There is an exception in the Defective Premises Act to latent damage, and that links to the negligence claims. And there's a couple of other aspects which we might look at in terms of claims to recover the cost of, for example, fire safety defects, and we've got the claims in contract, and that's not contracts in the lease, that's contract as in the specific purchase contract. So if a leaseholder bought their property off plan within the last 6 years, there might be a claim between them and the developer they purchased on. Section 38 of the Building Act, again, an amendment by the BSA. This isn't in force yet, so we won't spend any time on that. And negligence and nuisance, both common law, county court actions, which may or may not be of assistance in these cases, specifically may not be of assistance.
I think that, so the purpose of these last slides is that when you're looking at whether or not you can recover the cost of remediation of remedying relevant defects or interim fire safety measures as a service charge, you're also going to be looking at how you're going to cover these costs other than by asking the leaseholders for them, and you're going to be looking at who you can bring claims against. Remediation contribution orders is likely to be one of the most useful tools, but Defective Premises Act claims are something that you should definitely look at. The issue with Defective Premises Act claims is that it has to be brought by the leaseholders, and if the leaseholders don't succeed in that claim, then they'll be lumped with some very significant costs. They're likely to be claimed to the brought in the High Court, and the landlord's going to throw their entire legal team at it. And because there's not very many cases on Defective Premises Act and fire safety works, it's still something of a legal sort of unknown. Negligence and nuisance aren't likely to be of assistance. Negligence because of the rule against pure economic loss and Murphy and Brentwood, which means that you can't recover the cost of actually remediating the building, and nuisance because the caveat lessee principle, that the lessee takes the flat in the condition in which it was purchased. Section 38 of the Building Act was a provision, will be a provision that allows for civil actions for breaches of the building regulations, but it hasn't been brought into force yet.
I'm conscious that we've got about 3.5 minutes to go through a number of definitions of associated companies and persons. I understand the slides will be available, so if we can whiz through some of these and then see if we've got time for at the end. I can cover this off fairly quickly. We touched on the importance of associated companies when dealing with statutory waterfall. So, if you're looking at whether the relevant landlord was responsible for the relevant defect, it's not just the landlord, it's anyone associated with them. With remediation contribution orders, you're not only able to make applications against the developer, but also any company associated with the developer. When you're looking at contribution, whether the landlord meets the contribution condition, you're looking at all the companies associated with that. And there are also, in addition, building liability orders by which you can make claims like Defective Premises Act claims. You can pass them on to associated companies. And so very relevant, and Section 121 defines associated company. The one thing is that to note is that the definition of associated company will change depending on what you're looking at in the legislation, and for the purpose of determining whether the identity of a landlord group within paragraph 3 of Schedule 8 of the Building Safety Act, it sort of disapplies the associations that relate to directors, as you'll see. And so if we go on to the next slide, if a person's interest in a relevant building is held on trust, any body corporate which is a beneficiary is an associated person. A company is associated with any person who was a director of that company between 14th February 17 and 22. That's very broad, but again, it doesn't apply to determining the landlord group for the purpose of the contribution condition. And a company is associated with another company if either company shared a director between the 14th of February 17 and 22. Again, that doesn't apply for the purpose of determining the identity of the landlord group, but it does if you're looking at remediation contribution orders, for example.
So again, very broad, sort of wide net. But these are the ones to look at. So if on the 14th of February 2022, one of the companies controlled the other, or third body corporate controlled both of them, and the next slide explains in some detail that I won't go into how you work out whether a company controls another company. Most of it's common sense, to be honest. If a company owns 75% of the shares of another company, it's associated with that company. A few points, a few miscellaneous points that are worth noting. There is going to be a provision that will be brought into force, newly inserted Section 20D of the Landlord and Tenants Act 1985, which will require landlords, RMCs and RTM companies to effectively exhaust every possible avenue of funding before looking to recover remediation costs from leaseholders as a service charge. And that would include things like the building safety fund, which is important for any building that has combustible cladding. And the building safety fund, of course, has now been extended to intermediate buildings. Service charge demand is going to have to include some information for higher risk buildings, as buildings which exceed 18 metres or 7 stories. We've already touched on lease extensions and qualifying leases. I think that probably brings us to the end of our webinar. I think you've removed the conclusion for me.
Sorry.
That's all right. It's okay. I'm used to overrunning. Emma's a lot more time sensitive than I am. Should we have a look at see what questions we've got, Fanny?
Yeah, I can just stop sharing the screen here. There's a few questions here.
Okay, so do fire stopping / compartmentation costs form part of limitations payable by leaseholders, or does this only apply to cladding? I think hopefully we've answered that question. So the limitations in Part 5 and Schedule 8 of the Building Safety Act apply to any relevant defect, and that will include fire stopping and compartmentation. It doesn't just include cladding. Cladding is a part of it. It includes anything that might cause a fire safety risk for the occupants of the building. The second question is, what about works that are not specifically... Oh, there we go. What about works that are not specifically fire related but actually have an impact? Right, so if they're not fire safety related, the only other type of work that will be covered by Part 5 and Schedule 8 is something which causes a building to collapse or puts a building at risk of collapse. Anything else won't be covered. It isn't a building safety defect.
Associated company, I think we've possibly covered that, and if not, the slides will be available.
Happy to answer more specific question about associated companies. Somebody's asking here, is electrical work picked up, or is considered a relevant defect? Only if that electrical work leads to a fire safety risk, I think would be the answer to that question. In a relevant building, yes, yeah.
Copies of the slides will be available.
We will send you copies of the slides. Problematic smoke ventilation system. Oh, we've actually got that one. We've got that case that involves that very question. It's not an easy question to answer. The question is whether that smoke ventilation system causes a fire safety risk, and that's going to depend on a very specific range of facts, and you'll have to rely on your expert evidence to assist you with that one. Do we have time for any more? Do the leaseholder protections apply to building under 11 metres if they are separate to blocks that are relevant buildings, if they're at the same schemes? Right, okay. Those are some good questions. So the question here is, do the leaseholder protections apply to buildings which are under 11 metres, but they're not connected to other blocks, but they are part of an overall single service charge scheme? And the answer to that question is, if it's not structurally connected to any building which is over 11 metres, then that building won't be a relevant building for the purpose of the legislation. It doesn't do, unlike the right of first refusal, and there was a case called Longacre Securities and Carrot, which said that building could include multiple buildings that share the same service charge scheme. That's not the case here. It's a case of looking at the physical building. It's a case of, if you've got a structurally detached building that isn't connected to any other building, and it's under 11 metres and 5 stories, and it won't be a relevant building for the purpose of the legislation. So
I think that's all the questions that we have.
I'm
on the
actually
box.
only 5 minutes over, which for me is quite good. So thank you.
Thanks so much, Vicky.
Not bad at all. Thank you both for your time today. That was brilliant. Thank you for everyone who has joined us today. As I mentioned earlier, the webinar has been recorded, so I'll be able to provide you all with a copy of that later today, as well as a copy of the slides from Roger and Emma. And we have a lot of other webinars coming up over the next few months, also a few more with Brethertons. So if you want to have a look on the News on the Block website, you'll be able to register for all of those. Otherwise, thank you for joining us. Thank you both again for your time, and I will see you on the next one. Thank you. Bye.